And next up, we have Dr. Eloisa Lopez, or I'm sorry, Eloisa Lopez and
Not a
Dr.
doctor.
Sorry about that. Yeah. And Julie Gunnigle. And I'm sorry about this. They're going to be presenting their work, eliminating our understanding of leveraging community partners in policy action by presenting on the topic, keeping families together, preventing pregnancy surveillance and criminalization. Eloisa Lopez is an Arizona native and the executive director of Pro-Choice Arizona, the Abortion Fund of Arizona, and PCAZ's Action Fund. She first entered the organization in 2017 as an abortion fund helpline volunteer and has served in her existing role for the past 5.5 years. Her work has been focused on merging the narrative of maternal health care with abortion care while increasing access to both. Additionally, she's expanded her focus to include pregnancy and family justice. So apologize for getting that wrong at first, but it's really, really nice to meet you and excited to hear more. Eloisa did not step into reproductive justice work by way of specialized education, but rather through lived experiences that have fortified her commitment to justice, such as parenthood, having abortions, and involvement within the unsettling family court system. She's proud to share with others that becoming involved in movement work truly saved her life. Her experiences of living through domestic violence as a pregnant person and fighting the family separation system keep her grounded on the bigger vision of autonomy, abolition, and liberation. She currently serves on Arizona's Department of Health Maternal Mortality Review Committee, is an active member of various reproductive health coalitions in Arizona and across the country. In 2021, Eloisa was nominated for the Rockwood Leadership Institute's Fellowship for Leaders in Reproductive Health, Rights, and Justice. In Arizona, she co-launched a judicial bypass coalition for young people's access to abortion care and co-led the development of the Arizona Reproductive Justice Coalition during 2020 and 2021. Julie Gunnigle is a local loudmouth attorney and activist who fights for justice in our criminal legal system, for funding in our public schools, and for reproductive justice for our families. She's a former prosecutor of financial crime and public corruption for the Cook County State's Attorney's Office and a current co-VP of legal affairs for NCJWAZ. Julie is also the co-founder of Full Spectrum Law Collective, which is a legal practice where she focuses on impact litigation around the criminalization of pregnancy and the war on drugs. She remains committed to transformation in our criminal legal system and holding those who abuse their power accountable. I will now turn the floor to Ms. Lopez and Ms. Gunnigle.
Thank you so much for the introductions, and really excited to be here. So much gratitude for ASU inviting us to this event, and always excited to be in partnership with Julie Gunnigle for this work. I'm with Pro-Choice Arizona Action Fund here in that capacity today, and as named, I come into this work as a community member who's experienced various intersections impacting pregnancy and maternal health. And just want to ground us to moving into this conversation that most of you are probably aware, but the Arizona Supreme Court ruled to reinstate an abortion ban from the 1800s. And this is detrimental to maternal health across our state, and also those who are wanting pregnancies. So just really grateful to be in this work and having been in this work for so long. Quick overview about our organization. We operate a statewide abortion fund, and we center abolition and reproductive justice values to prioritize community needs. Reproductive justice encompasses not only the right to parent and the right to choose to not parent, but it's also directly related to the community policies in which we can raise our families. So our work is really developed and informed by the community we engage in. This is not charity work for us, this is survival work. And through our abortion fund, we operate a helpline where individuals reach out to us to request support and financial assistance to access abortion care. And in those conversations, we also hear the intersections of their lives and what other issue areas they are up against. And that work is what informs what we do today, which leads us to last summer, we began engaging with Jade, who is a Native woman who lived in Yavapai County. And you know, at the time that we were engaging with her, we had learned through this New York Times story, which really highlighted her journey of being pregnant as an individual who had a past history of substance use, but was sober at the time of her pregnancy, was prescribed Suboxone from her provider, and was told to remain on it, only to then give birth, have a DCS investigation opened up on her based on her past history and the current medication she was on, had her child removed, and has not been able to be reunited with her child. And from what we know now, after 4 years of this occurring, Jade had her parenting rights severed and lost access to her child. So in learning Jade's story, this really opened up for us this issue, and also being personally connected to this issue of domestic violence and family separation through the family separation court systems. This was an important issue area for us to follow through on and to explore how do we utilize these experiences from our community to really create community-centered policies and legislation.
I think this is where I pick up, and as
Yeah.
always, delighted to present alongside the amazing Eloisa Lopez. What we're going to talk about this afternoon, the conversation we'd like to start, is going to be heavy. So maybe the best place to start is with some bright spots, because there have been 2 recent developments in DCS law that you ought to know about in contemplating what substance use during pregnancy looks like on the legal end. So the first is the case of Lindsay Ridgell v. Department of Child Safety. This was a case where Lindsay had hyperemesis gravidarum, that really severe form of nausea during pregnancy that pharmaceuticals wouldn't touch. She was recommended medical cannabis from her provider, and when her healthy baby boy was born to her, she was referred to the Central Neglect Registry, making her unemployable for 25 years. She won at the Department of Administrative Hearings, but through appeals ended up losing that case until we had a decisive victory in Division 1. Similarly, another bright spot is the Philip B. case, which stands for the proposition that the Department of Child Safety can no longer overrule administrative law judges in making these sorts of determinations. So when you represent folks who are undergoing this really violent system, it is far more likely to lose rather than to win. So maybe these are the natural starting points. But let's talk about what the system looks like writ large. A ProPublica investigation into Arizona revealed that our TANF funds were being used in a way that's different than almost the rest of the nation. In 2021, we were only using, and I say we, the global we of Arizona, 11% of that federal funding to go to welfare funding for basic needs versus 67% to go to the Department of Child Safety. According to that same ProPublica deep dive, around 90% of the child welfare cases encountered were cases having to do with neglect, which is oftentimes tied to poverty rather than real abuse. That number has come down a little bit since that study, but it still remains true that during most of the last decade, DCS investigated the lives of 1 out of every 3 Black children in Maricopa County. This just shows you how out of, I don't know why that gray box is there. This shows just how out of step Arizona's system is. So when adjusted, oh, excellent, thank you. When factoring in child poverty, Maricopa County is alone in the country. It is a rate that is 17.5 times the rate of New York City when you consider the removal rate out of Maricopa versus, for example, New York City. Even adjusting for poverty, Maricopa County in particular tops the nation. So it caused this partnership between, my office and the kind of cases I take and the Pro-Choice Action Fund to ask the question, is DCS the right agency when it comes to referring people who use substances in pregnancy? And if the true underlying best practice, the humane practice, the anti-racist practice is focusing support on resources and prenatal care, it doesn't really make sense, or at least the conclusion we came to is it doesn't make sense that DCS might be the end-all be-all in these sorts of cases, because we know that healthy pregnancies come from access to resources and prenatal care. We also know that DCS's own view of their power start when a child is born. So if we're trying to support good public health policies of getting folks prenatal care, DCS can actually be a reason why people choose not to seek care. So just to give you kind of the highlights of our current system, there's a couple of underlying assumptions that take place. First, that prenatal drug use automatically leads to neglect and harms children. And this isn't a theory. This is actually what's written into our law, that under Title VIII, that any fetus that has been prenatally exposed to a scheduled substance has been presumed to be neglected under the law. Our law also presumes that people who use drugs cannot be good parents, and that the foster system is better for children than remaining with parents who choose to consume substances. Last, I think this is most important for this crowd, there is an inherent disconnect in the way the system responds to these sorts of cases. And in part, that's because the people who are most impacted, who are closest to the problem, by virtue of having a DCS case that's open, and the shame and stigma that are associated with it, they have a hard time advocating for themselves. But in some cases, they even have a legal detriment that they can't due to a gag order and child privacy laws. None of these things are supported by evidence. So in considering how good policy arises, one of the other questions we ask is why? Why has this been perpetuated for so long when it is undeniable that drug use during pregnancy is a barrier to care? It's undeniable that the screening system I referenced earlier in the chat is subject to some predictable racial biases. In fact, the woman who was at the center of the ProPublica investigation, she was a young Black mother, and she was told that she was being screened, even though blanket screening is not the hospital policy, because she is, quote, out of town. And we see how those racial biases translate into open DCS cases. In talking to providers, there's a qualitative study from 2022, basically saying that most providers don't necessarily understand what happens next in a DCS case, and that they found that a lot of the reporting to DCS under a mandated reporter system was due to anxiety that not reporting could cause some additional harm. So our current policy basically says that any fetus that has been prenatally exposed is presumed to be neglected. What this does is a few things. It shuts out the idea of confidential care for people who want to get substance use treatment during pregnancy. They cannot because of our mandated reporter system. They will be reported. We also know that non-consensual testing is an issue in Arizona. And we also know that the drug tests that are used during non-consensual testing are less reliable and not subject to the same chain of custody that you would expect in any other case where your most fundamental liberties, like your ability to parent your child, are at stake. So it's instructive today to listen to the amazing programming and models. I do challenge everyone who's listening to consider whether or not this is also the patient experience, because I can tell you, in representing the kinds of cases that I do, access to care and access to confidential care is a big issue, and it is, in a very real sense, perpetuating child separation, family separation in Arizona.
Thanks, Julie. I believe the next slide should be a video.
And by 15, I was a full-blown alcoholic, so addiction was something that I always struggled with. For all of the other pregnancies, I was able to stop using, but with the fourth pregnancy, which was my last child, it was extremely difficult. That pregnancy came from a sexual assault, so it was very unplanned, and during that time, I also faced other challenges. I was homeless, sleeping in my car, and didn't have much support from my family or friends. When I gave birth to my daughter in 2016, she was immediately taken or removed from my custody by child welfare. They had told me that if I wanted to see her, I would have to get up and go to the nursery to visit her, supervised. It was challenging to have to get up and go to the nursery to visit her, but at the time, that was the only way that I would be able to see her. And I was initially told that I would not be able to breastfeed her, which kind of made it hard for us to really bond. You know, I was able to breastfeed my other 3 children, so that was something that I had been used to, like after giving birth to my child. Shortly after leaving the hospital, it just caused me to spiral deeper into my addiction. Not being able to have my daughter with me caused me to fall into like a really dark place, and I ended up going back to jail. The last time I was in jail, which was only 6 months, my daughter ended up being adopted. And going through that just let me know that I needed to turn my life around. That was kind of the wake-up call that I needed to get into a position to ensure that if I ever wanted to have the chance to see my daughter again, I knew I would have to do something different with my life. We see this happen more than not. Hospitals are drug testing mothers without their consent, especially with women of color that give birth. And one of the biggest issues with that is when mothers are pregnant and they're suffering from substance use, they don't want to go to a hospital provider because they're in fear of being separated from their child. And we need to ensure that hospital providers can be trusted again, because we're jeopardizing women's health and the baby's health by women not seeking medical care and not getting the medical care and attention that they need while they're pregnant.
So in Stephanie's story, we hear the amount of trauma that she goes through after being separated from her child. We also hear her name that she didn't actually get support services until after the trauma and harm started to roll out for her. And as Julie named, and we're hearing Stephanie name, pregnant people are avoiding prenatal care for fear of these repercussions, for fear of being punished and criminalized. And what we are advocating for is there's a different way we can build a system that is truly supporting pregnant people who utilize substances, and also advocating to keep families together and offer the support models that pregnant people need when faced with these substance use issues. So in my role in the Department of Health's Maternal Mortality Review Committee, we've been analyzing data, right, from individuals who have passed. And through this graph here, we can see there has been an increase. We also know overall, like, our state is continually on the rise for maternal mortality. And as I named, this abortion ban now in place is only going to make this situation worse for pregnant people. The committee data shows that mental health conditions and substance use are the top issues that these individuals who have passed were facing. In our case reviews, we hear and see pregnant people, excuse me, not here, but we are reviewing in the notes of medical records and files that pregnant people have disclosed, I need support, and only to reach a dead end. There are no providers who are wanting to work with them. Maybe they're in a rural area where there's already a lack of maternal health care infrastructure for them, and end up going through hospital systems to give birth, only for them to roll out with a DCS investigation, with trauma, or spiraling back into substance use addiction, and which ultimately can lead to their death. The data show that over 90% of these cases the committee has deemed these could have been prevented with the right systems in place to support pregnant people. So the purpose of this committee is to really analyze the data and really propose policies for elected officials, for our government, for agencies to consider. And this committee has also named the relationship with DCS needs to change. We need to move away from reduce mandated reporting requirements, ensure that there are safety between the patient and provider relationship, keep advocating to keep families together and doing what's possible so that pregnant people can be honest about either their substance use during pregnancy, or if they want treatment, to be able to disclose without fear of retaliation and punishment when it comes time to actually give birth and keep families and stay with their newborn. There is a lot of trauma in that separation between the infant and the birthing person, and we cannot overlook that. We cannot continue to overlook that this is not harming people. It's harming the infant, it's harming the birthing person. And as an individual who has 2 children, has gone through pregnancy and birth, who's also experienced separation from my 1-year-old through the family separation systems, that this is devastating to the mental health, to the recovery of the pregnant person, to the postpartum experience. And as we're seeing in the data, this is increasing horrific outcomes for pregnant people.
So if we keep on hearing these themes from community, the question then is, well, what do we do about it? How do we translate what it would actually look like to support birthing people and keep them together with their newborn? One possible solution, and I'm going to be presenting 2 different legislative solutions to you today, is having protections and safeguards around informed consent. One of the things that we continually hear from people is that they don't know that disclosing substance use to their provider will place them in the family separation system, or sometimes even they are tested without their consent. If you start with the premise that all humans should have sovereignty over their own bodies, the natural endpoint of that is that consenting to a drug test or a drug screen ought to be voluntary and people ought to understand the consequences when they are consenting. So we are looking forward to introducing a prenatal informed consent bill at the legislature next year so that people can truly understand and feel safe that they're not going to be drug tested without their full and informed consent. The second piece of legislation that we are looking forward to introducing next year and hope will gain support because this is more important than ever in light of the Supreme Court's decision on Tuesday is a solution for prenatal substance use. What would it look like to build a system where people can feel free to get treatment and know that they're not going to find themselves ensnared in the DCS system? What would it look like to still comply with federal law, because under federal law, some of these reports and notifications need to be taken, but what would it look like to divert them to the medical providers that can best care for the dyad and provide support around them? So what the Prenatal Substance Use Act does is it decouples DCS from these reporting requirements and establishes what would be an evidence-based plan of safe care to make sure that any substance exposed newborn and their parents have the ability to have real access to services, but that it's done in a way that is consensual, that is affirming, and that ultimately is penalty free and keeps the family together. And not only is this a great idea, other states have followed down this path. So in New Mexico, Nebraska, and Connecticut in particular, we see different moves to decouple DCS from substance exposed newborn reporting. And in a large part, those states have found success with this. They have found that people are more likely to seek prenatal care and that this sort of decoupling system is working. To the ad lib part of today, I can't not mention what this means in the context of Tuesday's court case as well. You know, Arizona used to be a heck of a lot more punitive when it came to substance exposed newborns. There's a case from 1993 out of Pima County where DCS in coalition with prosecutors attempted to criminalize someone for prenatal child neglect for consuming substances while pregnant. That came from an idea of fetal personhood, and Arizona is just one court injunction away from having their own fetal personhood statute from SB 1457 that was passed 3 years ago go into place. So it's more important now than ever to make sure that we have systems that are decoupled from punishment and that can end up serving real public health needs.
Yeah, thank you so much, Julie, for sharing this important information. And we turn it now over to any Q&A. I did answer one just now. Jocelyn in the chat asked, how can we help promote? So the phase we are in right now is engaging more stakeholders, right? So if this is an issue area your organization or community is impacted by or interested in engaging in, please reach out to us. We do plan to just continue education. We've been educating lawmakers in session this year. But yes, we need more community support so that, as Julie named, when we introduce these pieces next session, there is already momentum around them to bring them forward.